afternoon. Welcome to the Prosecuting Attorneys Association of Michigan Traffic Safety Training Program webinar captioned An Overview of Michigan's Recreational Marijuana Law. My name is Ken Stecker, and I'm one of two Michigan Traffic Safety Resource Prosecutors. And I want to thank you very much for attending today's webinar. On November 6, 2018, Michigan voted to legalize recreational marijuana. The law took effect yesterday, December 6, 2018. This webinar will provide an overview of the new law and will cover some of the following topics. What is allowed under the new law, prohibitions under the new law, civil, criminal penalties, and how the new law affects OWI investigations and marijuana driving cases. A little background before we get into the actual law. I think it's important to keep in mind as a background to this entire issue is federal law. Once again, we all know that the Federal Controlled Substance Act states that marijuana is a Schedule I substance, and they give the following reasons as to why it's a Schedule I substance. Also, another case that comes into play is Gonzalez versus Reich at 545 U.S. 1, 2005. It was a decision by the United States Supreme Court ruling that under the Commerce Clause of the United States Constitution, Congress may criminalize the production and use of homegrown cannabis, even if state law allows it for medical purposes. We also have the Cole Memorandum that basically is no longer in effect because when Jeff Sessions took over as U.S. Attorney, he basically said those memorandums are no longer any good. But one amendment that is important to keep in mind is the Rohrabacher-Farr Amendment that was passed by the United States Congress. And it was first introduced by the United States Congress back in 2001. And this is important to keep in mind if you're dealing with the U.S. Attorney's Office or if you're dealing with any federal investigation. It prohibits the Justice Department from spending funds to interfere with the implementation of state medical marijuana laws. That's important to keep in mind. One of your handouts that you have, if you notice, you have 5 handouts. The 5 handouts are to the right of you. You can see them down there below. You have the ATF open letter, an overview of the Michigan recreational marijuana law, a chart dealing with the penalties, and the actual MCL numbers, and what does the recreational marijuana law mean for OWI investigations. Those handouts, if you click onto that icon, you will receive those handouts. Wilson versus United States is one of those handouts. Please keep in mind under federal law, you have to decide as a medical marijuana patient or any type of marijuana that you're using, whether you want your gun or your marijuana, according to the ATF open letter and a case decided, Wilson versus United States, you have to make that decision. You can't have both. It's illegal to have a firearm and marijuana at the same time, and you could face federal penalties for that. The other question is, who will be the next U.S. Attorney and how will he or she handle this particular issue as we move forward under federal law? With that being said, we now have 3 different acts in Michigan. We have the Michigan Medical Marijuana Act that was passed in 2008 by the voters. We also have the Medical Marijuana Facilities Licensing Act that was passed by the legislature in December 2016. And as you already know, and I mentioned when I started this broadcast, we now have what's called the Michigan Regulation and Taxation of Marijuana Act. You'll know it by the acronym MRTMA. So now in the United States, we have 32 medical marijuana states and the District of Columbia. This is what we're seeing with respect to medical marijuana dispensaries in our state. This one happens to be an unlicensed medical marijuana dispensary in the Detroit area. We also saw this one. This is also an unlicensed medical marijuana dispensary in the Detroit area. Keep in mind, we have medical marijuana dispensaries that are in place that are properly licensed pursuant to the directive put out by the Licensing Authority Regulatory Affairs here in Lansing. Here's the plant. The reason I mention these plants, you'll see in a second under the Recreational Marijuana Act, as I will call it today, you can now, as a grower, grow 2,000 plants. So under the Medical Marijuana Facilities Licensing Act, if you want to be a grower under the Medical Marijuana Facilities Licensing Act, you can only grow 1,500 plants or get a license for up to 1,500 plants. However, under the new law, you now can get a license to be a grower to grow up to 2,000 plants. And I'll talk about that more in detail here in a couple of minutes. Here's what we're going to start seeing in Michigan, either as a medical marijuana dispensary or growers or whatever. Certainly you can't do what's in the left-hand corner there at the bottom. You can't have your gun and your marijuana at the same time. That is illegal. This is also what we're going to see, secured transporters, certainly under both the Medical Marijuana Facilities Licensing Act and also the recreational marijuana law. We're also going to see this very popular product here. You'll see this more so as we go forward. This is the #1 popular product in Colorado, both under the medical marijuana law in Colorado and the recreational marijuana law. This is also what we'll start seeing, and THC patches, and of course the money will be involved. And we'll talk more about the money here in a minute. And of course, transporting the money. We now have 10 recreational marijuana states. Michigan's the only Midwest recreational marijuana state. That means certainly other individuals from around this area, from other states, will certainly be coming into our state to purchase recreational marijuana because they can do that legally. There's no prohibition from them doing that legally as long as they're in our state purchasing it. When they leave the state, certainly that's another issue. That's the Interstate Commerce Clause issue that comes into play. And certainly under federal law, they could be charged and convicted for that. Here's what we'll start seeing. We'll start seeing billboard signs like this around our state soon. Most likely not for another year because as you'll see in a second, these recreational marijuana dispensaries will not be up and about until about another year from now. So why Michigan? Why did they choose Michigan as one of the targets in terms of being a recreational marijuana state? The advocacy groups believe they had the momentum with them, the resources, the history behind them, with the medical marijuana law and how that turned out for them, the election trends, as you can see in the far right-hand corner, and certainly the results were somewhat consistent or somewhat in the middle there between what you see over there in the bottom right-hand corner. 56% voted in favor of this, 44% voted against it. So let's talk specifically about the Michigan Regulation and Taxation of Marijuana Act, also known as, and I say this affectionately, MRTMA is the best way I can say it. And let's see what this is all about as we delve into this. First of all, you'll see, as to the act itself, you'll see there are 17 different sections within the act. You see the 17 different sections within the act. To me, these are the most important section for prosecutors and law enforcement to deal with. That would be Section 4, Section 5, and Section 15. Actually, it'll be Section 3, Section 4, Section 5, and Section 15. So you'll see at the top, the one dealing with the definitions, that's my Section 3, MCL 333.27953. Certainly, without a doubt, the next section is very important for us to know, the restrictions on the act. The next one, Section 5, permitted acts. Those are the big three. And then what makes it the big four? Further down, 3 from the bottom, MCL 333.27965. Without a doubt, and we'll talk about that today, is extremely important. So here's what it does. First of all, before I even get into what the law allows, keep in mind under Section 2 of the Act, it states that the purpose of the Act is to make marijuana legal under state and local law for adults 21 years of age or older and make industrial hemp legal under state and local law. Section 5, this is Section 5 right here, of this act states that for a person, and I'm going to go through this slowly, 21 years or older, the following acts are lawful, are not offenses, and are not grounds for seizing or forfeiting property, search or inspection, arrest, prosecution, or penalty, or to deny any other right or privilege. Number 1, possess, internally possess, use, consume, purchase, transport, or process not more than 2.5 ounces of marijuana. Of that amount, not more than 15 grams may be marijuana concentrate. Those are your medibles. Number 2, within the person's residence, possess, store, or process not more than 10 ounces of marijuana and any marijuana produced by marijuana plants cultivated on the premises. Now, under Section 4, which we'll come to in a minute, any amount possessed over 2.5 ounces must be stored in a container or equipped with locks or other functioning security devices that restrict access to the contents of the container or area. Number 3, within the person's residence, cultivate not more than 12 marijuana plants for personal use. There is a limit of 12 plants at one time within a single resident. Under Section 4, the plants cannot be visible from a public place without the use of binoculars, aircraft, or other optical aid, or outside of an enclosed area equipped with locks or other functioning security devices that restrict access to the area. Number 4, this is a big one. Give away or transfer without payment. Notice that right there, without payment, up to 2.5 ounces of marijuana to a person at least 21 years of age, as long as the transfer is not advertised or promoted to the public. Of that amount, not more than 15 grams may be marijuana concentrates. Number 5, use, manufacture, possess, or purchase, or distribute, or sell to a person at least 21 years of age marijuana accessories. And the last one, assisting another person at least 21 years in acts listed above. That's what is allowed under the Recreational Marijuana Act. Here is what the law does not allow. This is important to know each and every one of these from Section 1A all the way to Section 1I. And we'll go through these prohibitions slowly, and we'll see how they are tied in as we move forward. The first one is operating or being in control of a motor vehicle, aircraft, snowmobile, ORV, or motorboat while under the influence of marijuana. Number 2, transferring marijuana, infused products, or marijuana accessories to anyone under 21. Number 3, possessing, consuming, purchasing, cultivating, transporting, or selling marijuana if under the age of 21. Here's a big one with your BHO explosions. Separation of plant resin by butane extraction or another method that utilizes a substance with a flash point below 100 degrees Fahrenheit in any public place, motor vehicle, and this is important, within the curtilage of any residential structure. Number 4, consuming marijuana in a public place or smoking marijuana where the owner, occupant, or manager of a property prohibits it. Number 5, cultivating marijuana plants that are visible from a public place without use of binoculars, aircraft, or other optical aids. Number 6, consuming marijuana or infused products while operating, navigating, or being in control of a motorboat, aircraft, snowmobile, ORV, or motorboat, or a motor vehicle or motorboat. The next one is a very important one, smoking marijuana within passenger area of a vehicle on a public highway. The next one, this is also a big one, possessing marijuana, infused products, or marijuana accessories on school grounds, in a school bus, or, this is very important, in a correctional facility. And lastly, possessing more than 2.5 ounces of marijuana within your residence unless the excess is in a locked container or locked area. So my understanding and my interpretation of this is that under Section 4 of this Act, the following acts are unlawful with regard to the amount of marijuana. The following acts are unlawful without regard to the amount of marijuana at issue or the age of the person. That would be Section A, operating, navigating, or being in physical control of any motor vehicle, aircraft, snowmobile, off-road recreational vehicle, or motorboat while under the influence of marijuana. The appropriate enforcement certainly remains to be seen as to how we're going to handle that. The next one, as to it's unlawful without regard to the amount of marijuana at issue or the age of the person, is consuming marijuana while operating, navigating, or being in physical control of any motor vehicle, aircraft, snowmobile, off-road recreational vehicle, or motorboat, or smoking in passenger area of the vehicle upon a public highway. A violation of this section for the use of marijuana is punishable as a 90-day misdemeanor. And lastly, in terms of this particular section, this act is unlawful without regard to the amount of marijuana at issue or the age of the person. Actually, the prohibition is separating plant resin by butane extraction or another method using a substance with a flash point below 100 degrees Fahrenheit in any place, motor vehicle, or within the curtilage of any residential structure. And then certainly I listed the following additional acts that are not authorized by the Recreational Marijuana Act. These acts may continue to be punishable as a crime, depending on the amount of marijuana at issue and the age of the person. Please know that, and we'll delve into that a little more here in a minute. This is a very important section. This is under section 333.27954.5. This section will come into play as it did with the language that was mentioned in the Michigan Medical Marijuana Act. All other laws inconsistent with this act do not apply to conduct that is permitted by this act. So this is really important to keep in mind. I talked about this last week. I'm not going to talk about this too much, but you'll see where there may be issues as to how this will conflict with MCL 257.6258 in the sense that, as was done in the Michigan Medical Marijuana Act with the Kuhn decision, where Mr. Kuhn, he was under the influence. The court basically ruled in his favor and said that the Michigan Medical Marijuana Act trumped the MCL 257.6258, and therefore prosecutors will have to show and police will have to basically investigate that the individual is under the influence of the THC at the time he or she is driving. I anticipate that will be the case with every driver out there, regardless of whether they're taking recreational marijuana, medical marijuana, that you will eventually have to show the individual is under the influence of that THC at the time he or she is driving. Basically, they will take, the argument will be that, hey, Kuhn's in place under the Michigan Medical Marijuana Act, therefore the Kuhn should, in essence, apply to recreational marijuana, in essence, dealing with the driving issue and under the influence. Key terms under the under the Michigan Recreational Marijuana Act is this is a key term: resin extracted from any part of the plant of the genus cannabis. This deals with the concentrates, and I'll talk about that here in a second. This too is a very important term. The marijuana-infused products, topical formulations, the tinctures, the beverages, the edible substances, or similar product containing marijuana or an extract from marijuana and other ingredients, and that is intended for human consumption. These are the licenses that eventually will be issued by LARA, most likely a year from now. These types of licenses, you'll have the grower, a Class A grower up to 100 plants, a Class B grower up to 500 plants, and as I mentioned, we now will have Class C growers up to 2,000 plants. We'll have the processors, the retailers, the safety compliance facilities, the secure transporters, and the micro businesses. The licensing criteria, they will approve an application if an applicant submits a complete application. You'll notice number 3 bullet, applicant will not operate in a residential area or within 1,000 feet of a K-12 school. The licenses will be good for 1 year. There's other criteria or other restrictions that will apply for certain licensees. You see 3 of those below for Class A grower or micro business. Applicant must be a resident of Michigan. This is also important for those prosecutors that are listening, and also for any chiefs or any chiefs at any municipality or city, village, or township that's listening, dealing with your employees. This is something that's under the section 2794.3. It does not require an employer to permit or accommodate conduct allowed by the act in the workplace or on the employer's property. It does not prohibit an employer from disciplining an employee for violating a workplace drug policy or for working under the influence of marijuana. And lastly, it does not prevent an employer from refusing to hire, discharge, discipline, take an adverse employment action against an individual because of that person's use or possession of marijuana in violation of a workplace drug policy, or because the person was working under the influence of marijuana. Rights of landlords does not prohibit a person from prohibiting or regulating the consumption, cultivation, distribution, processing, sale, or display of marijuana-infused products or accessories on property they own, occupy, or manage. However, the lease cannot prohibit a tenant from possessing and consuming marijuana by means other than smoking. Municipalities, you may get questions about this from some of your municipalities. If you're dealing with the municipalities, the law creates an opt-out system. That means the municipality may adopt other ordinances that do not conflict with the law or rules promulgated thereunder. Reasonable restrictions on signage, time, place, and manner restrictions. Authorize the sale of marijuana-infused products for consumption in designated areas. Authorize the sale of marijuana-infused products for consumption at special events. And designate a violation of the ordinance as a civil infraction with a penalty up to $500. There's this vicious rumor going around that these municipalities have to opt out within 10 days after the law took effect. That's a vicious rumor. That is not true in any way. The municipalities can opt out whenever they're ready to opt out. They don't have to opt out tomorrow, next month, 3 months from now. Whenever they want to opt out, they can opt out. If they do decide to opt out, though, the electors in that community may petition to initiate an ordinance, in essence, allowing them to, in essence, the ordinance would say, hey, listen, we want 10 dispensaries in our city, village, or township, even though you've decided to opt out. We have enough petition signatures to get it on the ballot in order for us to vote on it. They will need 5% of the votes cast for governor in the last election. That would be this past election. If the ordinance limits the number of facilities, municipality must create a competitive process to determine which applicants are best suited to operate in compliance with the law. Authority of LARA, they have other authorities similar to what they have under the Medical Marijuana Facilities Licensing Act. The one thing they don't have is a board like they do under the Medical Marijuana Facilities Licensing Act. That will remain to be seen whether they, in fact, do create a board. This is a couple of things you need to keep in mind. They may not promulgate rules that limit the number of facilities licenses. It requires the customer only to provide retailers with identifying information other than ID. It prohibits a facility from operating in the same location as a medical marijuana facility. That is a big one. And then, of course, there's other rules that are in place that are in place that eventually will be implemented by LARA. This is one thing I want to talk about before I get into the penalties. This is extremely important for everybody to know. Under the Medical Marijuana Facilities Licensing Act, there was a tax that was imposed on the retail income of each medical marijuana provisioning center. That was a 3% tax. And then also under the Medical Marijuana Facilities Licensing Act, taxes will not apply to registered primary caregivers or qualified registered patients, as they're not required to be licensed under the new regulatory scheme. Now, why do I bring this to your attention? Well, first of all, under the Medical Marijuana Facilities Licensing Act, this is how the money from that 3% tax was to be distributed. 25% to municipalities, 30% to counties, 5% to counties, and then you see the breakdown as to the money. That's all good and well, but here's the problem. We also had under the Medical Marijuana Facilities Licensing Act this particular section, and it reads in pertinent part as follows. If a law authorizing the recreational or non-medical use of marijuana in the state is enacted, this section does not apply beginning 90 days after the effective date of the law. In essence, if recreational marijuana becomes a reality in Michigan, which it did, because it did that through an initiative, not by the legislature, the medical marijuana will not be taxed. So all of this money right here that was to be collected from that 3% that was to be imposed on those medical marijuana dispensaries goes away on March 6, 2019, 90 days after December 6, 2018. Notice some of the money went to the Michigan State Police, to the county sheriffs. All of that goes away. And here's how the money will now come in the form of a tax. It will come this way. They'll tax until 2022, 20% annually goes to research efficacy and treating medical conditions of veterans, 15% to municipalities with retailers or micro businesses, 15% to counties with retailers or micro businesses, 35% to school aid for education, 35% to Michigan Transportation Fund for repair and maintenance of roads and bridges. No money to law enforcement and no money to prosecutors and no money to medical treatment. This is how the money is broken down. So the taxes will be this way. That money, in terms of how it's broken down, that will come from an excise tax on each retailer and microbusiness at rate of 10% of all sales. Now, I do want to go into the penalties, and I'm going to go through this very slowly because this really is what is applicable to you. You'll notice this is the section MCL 333.27965. It's broken down into 4 parts. Please remember, it's broken down into 4 parts. Here's part 1, and I'm going to read it, and then I'm going to tell you what it means in my opinion. Now, certainly check with your prosecutor to make sure you get the advice from the prosecutor, as the prosecutor has the final say as to his or her interpretation of this particular section. Here's how it reads. It says a person who commits any of the following acts and is not otherwise authorized by this act to conduct such activities may be punished only as provided in this section and is not subject to any other form of punishment or disqualification. And then it says this, unless the person consents to other disposition authorized by law. Here's section 1. Except for a person who engaged in conduct described in sections 4.1a, 4.1b, 4.1c, 4.1d, 4.1g, or 4.1h, a person who possesses not more than the amount of marijuana allowed by section 5, cultivates not more than the amount of marijuana allowed by section 5, delivers without receiving any remuneration to a person who is at least 21 years of age, not more than the amount of marijuana allowed by section 5, or possesses with intent to deliver not more than the amount of marijuana allowed by section 5, is responsible for a civil infraction and may be punished by a fine of not more than $100 and forfeiture of the marijuana. Now, it took me several tries, I would say at least, 20 tries, to understand what the heck this means. And I think I'm finally able to figure it out. Here's the way I read it. A violation of section 4.1e, that's consuming in a public or where it's prohibited, section 4.1f, cultivating where visible from public place or in an unsecured area, or section 4.1i, possessing more than 2.5 ounces within a residence where the excess is unsecured, where the person otherwise possesses not more than the amount of marijuana allowed, cultivates not more than the amount allowed, delivers without receiving remuneration to a person who is at least 21 years of age, not more than the amount allowed, or possesses with intent to deliver not more than the amount allowed, is facing a civil infraction and may be punished by a fine of not more than $100 and forfeiture of marijuana and the marijuana. Note that violations of section 4.1a, 4.1b, 4.1c, 4.1d, 4.1g, and 4.1h may be prosecuted under existing law. That's the way I read it. Here's the next section. It says, section 333.27965.2, except for a person who engaged in conduct described in section 4, a person who possesses not more than twice the amount of marijuana allowed by section 5, cultivates not more than twice the amount of marijuana allowed by section 5, delivers without receiving any remuneration to a person who is at least 21 years of age, not more than twice the amount of marijuana allowed by section 5, or possesses with intent to deliver not more than twice the amount of marijuana allowed by section 5. First violation, second violation, civil infraction, third violation, a misdemeanor. In essence, this is between 2.5 ounces and 5 ounces. That's the way it should be read. So in essence, the way I see this is a person who possesses not more than twice the amount of marijuana allowed, cultivates not more than twice the amount of marijuana allowed, delivers without receiving any remuneration to a person who is at least 21 years of age, not more than twice the amount of marijuana allowed, or possesses with intent to deliver not more than twice the amount of marijuana allowed, is for a first violation, civil infraction, second violation, civil infraction, third violation, misdemeanor. However, if the person is over the allowable amounts, any violation of section 4 would allow prosecution under existing law. Here's the next section. This section is MCL 333.27965.3. This deals with the minors. It says, except if a person who engaged in conduct described by Section 41A, 41D, or 41G, a person under 21 years of age who possesses not more than 2.5 ounces of marijuana or who cultivates not more than 12 marijuana plants, for a first violation, responsible for a civil infraction, for a second violation, responsible for a civil infraction. So here's the way I read this. A person under 21 years of age who possesses not more than 2.5 ounces of marijuana or who cultivates not more than 12 marijuana plants, first violation, civil infraction, second violation, civil infraction. However, any violation of Section 41A, operating a vehicle while under the influence of marijuana, Section 41D, separating a plant resin by butane extraction in a public place, motor vehicle, or within curtilage of any residential structure, or Section 41G, consuming while being in control of a vehicle or smoking within the passenger compartment of a vehicle upon a public highway by the person under 21 years of age would allow prosecution under existing law. That's the way I read it. Here's the big one. This one's huge. Section MCL 333.27965.4. Remember, there's 4 sections. This is the last section. In this particular section, it says, except for a person who engaged in conduct described in Section 4, a person who possesses more than twice the amount of marijuana allowed by Section 5, cultivates more than twice the amount of marijuana allowed by Section 5, or delivers without receiving any remuneration to a person who is at least 21 years of age, more than twice the amount of marijuana allowed by Section 5, shall be responsible for a misdemeanor. Now, they don't tell us what a misdemeanor is. Is it a 90-day, 93-day, 1-year misdemeanor? By default, and based on statutory law, that would be a 90-day misdemeanor, but shall not be subject to imprisonment unless the violation was habitual, willful, and for a commercial purpose, or the violation involved violence. So the scenario would be this. You have a warehouse full of marijuana that you're possessing or you're cultivating. You can have warehouse after warehouse after warehouse. You could have 10,000 pounds of marijuana in your possession. That's a misdemeanor because it's, as it says right there, that's more than twice the amount. There's no cap on it. So that's one thing to keep in mind. Also, it will not be subject to imprisonment unless the violation was habitual, willful, and for a commercial purpose, or the violation involved violence. So this is the way I also see it. Violations of Section 41A, and I'll go slow on this. Violations of Section 41A, 41B, 41D, 41G, and 41H, as well as delivery with remuneration and possession with intent to deliver with remuneration when possessing over twice the amount allowed amounts may be prosecuted under existing law. I'll say that again. Violations of Section 41A, 41B, 41D, 41G, and 41H, as well as delivery with remuneration and possession with intent to deliver when possessing over twice the allowed amounts may be prosecuted under existing law. This handout is one of your handouts. Please go to this handout when you have questions on this. That is the handout called the Michigan Regulation and Taxation of Marijuana Act Penalty Chart. It's something that is very detailed and something that, without a doubt, should be very helpful for you as we move forward in the future. Areas of concerns. These are many questions that have been sent my way, And certainly these questions may be unanswered until we have a court decide, or in essence, we have some other way these decisions or these questions will be answered. Here's one I saw on my own. How does law enforcement determine the amount of marijuana and the number of plants when there is no definitions of marijuana plant and marijuana plant to match the definitions in the Michigan Medical Marijuana Act and the Medical Marijuana Facilities Licensing Act? It's incredible that in the Act itself, we do not have a definition for marijuana plant and marijuana plant. I was stunned to see that. Number two, does a qualified patient exceed the usable marijuana possession limit for immunity to apply under the Michigan Medical Marijuana Act if the qualified patient possesses the maximum of allowed use of marijuana under the Michigan Medical Marijuana Act and allowed marijuana under the Michigan Regulation and Taxation of Marijuana Act? Can they have their cake and eat it too, in essence, is the best way to read this. The way I interpret this is that you are entitled as a medical marijuana patient to an amount that does not exceed 2.5 ounces. If you have more than that, regardless if you try to say it's recreational marijuana, you still do not have immunity under Section 4 of the Michigan Medical Marijuana Act. What happens if a person operates a recreational marijuana facility without a license, or operates a recreational marijuana facility before you can ever even apply for a license? What is the penalty? A civil infraction? Is this just a zoning enforcement issue? Once again, I believe you have to go back to Section 15 in order to address that particular issue. If a police officer issues a civil infraction ticket for recreational marijuana violation, do we need a police report to accompany it? Is the marijuana going to be seized, sent to the crime lab for testing, or do we just take a picture of it and not send it to the lab because the burden of proof is just preponderance? That's a question I'm not in a position to answer at this particular time. The next one is, what is the impact of recreational marijuana on a person's CPL? What is our responsibility? Once again, under federal law, based on the ATF open letter, and also the Wilson versus United States case, I believe that, in essence, they can't have their recreational marijuana and their gun at the same time under federal law, not under state law. So that gets to the next question. What is the impact of recreational marijuana and the purchase of a firearm? What about, this one's the big one, without a doubt. What about the issue of probable cause to search a vehicle when there is the order of marijuana? That is the $64,000 question. I believe that will eventually be decided by the court as to the outcome of that particular issue. Now, we have a case out of Roscommon County that has gone to the Court of Appeals under the Michigan Medical Marijuana Act that will, in essence, decide this issue when it comes to medical marijuana. In essence, the case of People versus Kaczmarek has been challenged by the defense attorney in Roscommon County. The Roscommon County Circuit Court judge bought the defense argument hook, line, and sinker that Kaczmarek is no longer relevant because now we have the Michigan Medical Marijuana Act. That case, as I mentioned, has been appealed to the Michigan Court of Appeals. This one, this is a tough one. I'm really at a quandary on this one because I think that will have to be case by case with the search. Certainly the argument will be made that Kaczmarek is no longer applicable, that the order of marijuana alone is sufficient for probable cause to search the motor vehicle, and therefore you need more than that, and you'll have to look at the totality of the circumstances as to whether the police had the probable cause to search that vehicle. It's a tough one. It's a real tough one. If a person who's taken into custody possesses marijuana that is not subject to forfeiture under the Michigan Regulation and Taxation of Marijuana Act, may the arresting enforcement agency seize the marijuana? Once again, that's a question for each police agency to make that decision because that falls into the next one. And we do have as you know, the Attorney General, when it came to medical marijuana, basically made a decision on this in Attorney General Opinion number 7262 with respect to the next question. If a law enforcement agency seizes marijuana under MRTMA, may the marijuana be returned following the person's release from custody. With respect to medical marijuana, the Attorney General addressed this in opinion number 7262 and basically said, concluded that the seizure and return of marijuana would require a police officer to commit federal crimes regarding possession and distribution of marijuana, and as a result, the prohibition against forfeiture under the Michigan Medical Marijuana Act is unenforceable due to the conflict with federal law. It would be interesting to see how this plays out with recreational marijuana. The next one is, does a person have to transport his or her recreational marijuana in his or her vehicle in a locked container? There is no mention of that as to transportation of the recreational marijuana and how it has to be transported under the Recreational Marijuana Act, like there is under the Michigan Medical Marijuana Act. So this will be really interesting. You stop an individual, the individual says, I have medical marijuana in my card, here's my car, here's my card and my separate piece of ID in order to be protected from arrest, and only the medibles have to, not the usable marijuana has to be enclosed in a case in the trunk of the vehicle. If it's the primary caregiver, if it's the qualifying patient, only enclosed in the trunk of the vehicle. I know it sounds complicated, but there are certain restrictions when it comes to medical marijuana patients transporting medical marijuana. On the other hand, if they're transporting recreational marijuana in that vehicle, there's nothing mentioned in the Recreational Marijuana Act as to how it should be transported. So in essence, to me, that means it can be transported anywhere in that vehicle and they don't face any consequences for that. If there are any questions, feel free to send those questions to me. That is in a nutshell where we're at as to the Michigan Regulation and Taxation of Marijuana Act. There will be a lot more coming. This is only the where we're at in terms of scratching the surface. We will have more updates as we continue to get updates ourselves. The last thing I want to mention is we have 2 upcoming trainings. We have Under the Influence of Cannabis, Understanding the Highway High on Thursday, January 17th, 2019 at the Kellogg Hotel and Conference Center in East Lansing. And also we have 5 different trainings scheduled for January in Grand Rapids, January 8th, Gaylord, January 9th, Bay City, January 10th, Kalamazoo, January 15th, and Ypsilanti, January 16th. What the recreational marijuana law means for prosecutors and law enforcement on OWI cases. Once again, as always, I want to thank you for attending today's webinar. I'm very grateful for that. And on behalf of Kinga Kaneki, my cohort, and the Prosecuting Attorneys Association of Michigan, I want to thank you for attending today's webinar. I said that once, but I'll say it again. And I look forward to seeing everybody in the future. And everybody have a great weekend. God bless.